Well, I'm delighted to be in this charmed circle. You represent a broad geography, and we've been brought together by a rather interesting organization doing the work of the Lord. I trust you still are.
Yes. Every day.
But when I was invited to come here today, I was asked to deliver the major portion of a talk I had given about 2 or 3 months ago at a meeting of this National Review Institute. So I shall proceed to do that, and it'll place a subject matter on the agenda for this session. I better get my glasses out.
And I think everyone has this, so you haven't had a chance to look at Senator Buckley's background, Judge Buckley's background. You've got it in front of you.
I haven't been able to keep a job.
You were commenting about he's like a millennial who changes jobs every year.
In any event, I begin this excerpt by saying, in my view, the serious problems we face these days are in major part the result of our abandonment of the Constitution's limits on federal authority. The architects of the American Republic had no illusions about human nature, which is the one constant in human affairs. From their study of the history of free societies reaching back to ancient Greece, they understood that the drive to accumulate power, whether by an individual despot or a parliamentary majority, was the historic enemy of individual freedom. They therefore incorporated two safeguards into the Constitution: its system of separation of powers with its checks and balances, and the principle of federalism. In describing the latter, James Madison explained, and I quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state." During the debates over the Constitution's ratification, many expressed a concern that the allocation of responsibilities was not clear enough in the document itself. As a consequence, the first Congress made it explicit in the 10th Amendment of the Bill of Rights, which provides that, quote, "The powers not delegated to the United States by this Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." The 10th Amendment's allocation of powers mirrors those of the venerable rule of subsidiarity, which assigns responsibilities to the lowest levels capable of handling them. Its effect is to decentralize political power and ensure, wherever feasible, that the decisions that most directly affect people will be made by those who are the closest to them and most familiar with both their priorities and the relevant facts. During our first 140 years, Washington largely observed those limits. With the advent of the New Deal, however, it began chipping away at the state's authority, largely through some rather imaginative constructions of the federal government's powers to regulate interstate commerce. But with the advent of Lyndon Johnson's Great Society, Congress began a wholesale assumption of the state's responsibilities. It has done so through a proliferation of programs that offer states and their subdivisions regulation-ridden grants of money for purposes that are acknowledged to be the sole responsibility of the states. Congress found its authority to create such programs in an unfortunate Supreme Court interpretation of the Constitution's Standing Clause, which empowers it to spend money, quote, to pay the debts and provide for the common defense and general welfare of the United States. The mischief lies in the words general welfare. During most of our history, the prevailing view was that that phrase did no more than place a limit on Congress's authority to spend by requiring that federal expenditures serve national as opposed to state or local purposes. Beginning with the 1937 case of Stewart Machine Company versus Davis, I'm sure none of you were taught that case in law school. Beginning with that case, however, the Supreme Court has held that in its pursuit of the general welfare, Congress is authorized to provide states with funds with which to implement programs that Congress itself has no power to write into law. The court recently summarized that holding as enabling Congress to use federal tax revenues to, quote, induce the states to adopt policies that the federal government itself could not impose. But because grants programs deal with matters that are acknowledged to be beyond Congress's constitutional authority, the court has ruled that the states may not be coerced into accepting the grants and their attendant regulations. 50 years of experience has demonstrated, however, that the states find it enormously difficult to decline to accept what is viewed as free money, whatever their conditions. Thus, the practical effect of the court's decision has been to empower Congress to, yes, effectively coerce the states into adopting Washington's approach to matters that remain the state's exclusive responsibility. Those programs, which are laden with the most detailed instructions, some of them running literally into the thousands of pages, now provide federal subsidies for virtually every activity in which states are engaged and have made a major contribution to the federal government's vast expansion. In the process, they distort state priorities, impose ponderous regulations on a myriad state and local activities, and deprive their citizens of effective control over how their own taxes are to be used. In sum, they have converted the states in too many ways into mere administrators of programs created in Washington and overseen by bureaucrats who are the farthest removed from where the money is to be spent. As one former Democratic governor put it, I honestly wondered if I was actually elected governor or just branch manager of Nebraska for the federal government. Members of Congress who have become addicted to grants programs, according to a recently issued Cato Institute study, there are now 1,386 of them, because they deal with matters that have the most immediate impact on their constituents' lives, such as housing, schooling, job training, potholes, you name it. I mention potholes because a recent senator was so focused on urban minutiae that he was nicknamed Senator Pothole. Therefore, the creation and securing of grants offer members of Congress the easiest way to rub elbows with voters and generate the favorable local headlines that will ensure their re-election. As a consequence, whereas those programs distributed just $24 billion in 1970, the year I was elected to the Senate, by fiscal 2015, when I published a book on that subject, that figure had reached almost $641 billion, or 1/6 of total federal spending, all for purposes that are none of Washington's business. Just 3 years later, according to the Cato study, that figure had grown almost 10% to $697 billion. To compound the injury, instead of concentrating on the critical problems that only Congress can address, its members now devote major portions of their time on matters that are none of their constitutional business. Witness the 30% of senatorial press releases that nowadays deal with the creation and securing of grants. In short, those programs have effectively nullified the 10th Amendment, and in the process helped undermine Congress's ability to function effectively. But what can be done about it? 4 years ago, I had the temerity to write a book with the title Saving Congress from Itself, in which I detailed the extraordinary systemic and financial costs of those programs at both the state and federal levels, and proposed a simple reform that would restore federalism, namely the conversion of these grants into block grants, free of federal directives telling the states how the money was to be spent. It is a reform that at one stroke would not only free the states to meet their responsibilities in their own way, it would reduce federal spending by major amounts in administrative costs alone, and rid Congress of a significant distraction from its central and national responsibilities, and restore the people's ability to control their own state and local affairs. Needless to say, Congress has yet to act on my suggestion. I recognize, however, that we now live in novel times. The power to move political mountains is passing from printed books to the social media, so there may be another way to force congressional attention. What I dream of is a tweet in which the president explains the problem and then advises Congress that henceforth he will veto any bill that tells the states how to run their own affairs. Such a tweet would stir up a vigorous debate of the merits of my proposal. It might even remind our countrymen that our Constitution indeed places limits on what the federal government may engage in, and that the enforcement of those limits might well be in their interest. If such a debate were to arise, I believe my reform would have a good chance of being adopted. Confidence in the federal government is at an all-time low, and our people still understand the virtues of the Constitution's allocation of governmental powers. According to a 2013 poll, today's Americans believe that state and local governments are best able to handle the following responsibilities by the indicated percentages. Housing by 82% of those polled, transportation 78%, education 75%, and welfare 69%. Those are precisely the kinds of responsibilities that the Constitution has reserved to the states, the kinds that federal agencies have taken over. That, in any event, is the subject of federalism, and this is the Cato study that updates the observations I had in that book. I think you'll find it fascinating and utterly depressing. In any event, that subject's on the table, and I want to take the liberty of sneaking in another subject matter for possible discussion. And this comes just before I increased the spacing. It was just one page of the original talk. It was at a breakfast sponsored by the Alliance Defending Freedom, and the subject was originalism and religion. And I'm about to make a shocking confession. In my case, I owe my commitment to originalism and religious freedom not to scholarship, but to the happy fact that I managed to graduate from an Ivy League law school without ever having taken a course in constitutional law. Accordingly, I was never taught the importance of such things as emanations and penumbras in ferreting out the Constitution's meaning, never weaned of my no doubt primitive view that its words ought to be taken at face value. That is why I continue to believe that the First Amendment truly guarantees the free exercise of one's religion, and that it does no more than prohibit the establishment of an official national church. The Supreme Court, however, has read more into that amendment than I can. From the time it interpreted the federal establishment clause to prohibit the use of non-denominational prayer in public schools, it has encouraged the notion that that clause requires not only that government refrain from preferring one faith over any other, but that it banish religion altogether from the public square. In doing so, the court has encouraged a developing hostility to religion as such that could not be further from what the framers had in mind. The founders of the American Republic valued religion not only for its own sake, but for the critical importance as a civil force. They believed it essential to the success of their grand experiment. A common theme that ran through their writings was that the Republic's survival and the liberties it was designed to protect depended on the morality of its citizens as informed and reinforced by their religious faith. Thus, John Adams asserted that, quotes, "Our Constitution was made only for a moral and religious people," and Washington warned that, quote, "reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle." And so it is hardly surprising that at the same time that Congress adopted the First Amendment, it also reenacted the provision of the Northwest Ordinance that declares that, quote, "religion, morality, and knowledge being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged." And early Congresses proceeded to make grants of land to serve religious purposes and to fund sectarian education among the Indians. End of sermon. Thank you. Thank you.